On Law Weekly today, some legal practitioners shared their views on the recent directive of the Chief Judge of the Federal Capital Territory, which barred magistrates in Abuja from issuing remand orders for the detention of very important personalities being investigated by the Economic and Financial Crimes Commission. We also have a recap of the top legal stories of the past week. In our interview segment, we chat with a senior advocate of Nigeria, Silva Ogwemo. He has over 27 years' experience as a legal practitioner within and outside Nigeria. In this interview, we talk about the violations of election campaign financing limits, the much talked about allegations of corruption in the judiciary, and more. Hello and welcome to the program. I am Shola Sheyedi. Let's begin with the views of some legal practitioners on the recent directive of the Chief Judge of the FCT barring magistrates in Abuja from issuing remand orders for the detention of VIPs who are currently being investigated by the anti-graft agency, the EFCC. It has continued to generate controversy as many lawyers remain divided over the legality of the directive. Many refer to the provisions of the Administration of the Criminal Justice Act 2015, which specifically provides that a suspect arrested for an offense which a magistrate court has no jurisdiction to try shall within a reasonable time be brought before a magistrate for remand. They say that this empowers the magistrates to issue remand orders. Others think that a magistrate who has no jurisdiction to hear a suit should not detain a person in connection with such suits. But here's the opinion of some lawyers on the issue.
It is absolutely, in my own opinion, not in order, because the section 293 is very clear about it. The section gave the magistrate the power to remand, even though he does not have the power to try. But I think, in my own opinion too, what the Chief Judge of the FCT is trying to portray is to avoid abuse. But avoiding abuse is not the position of the law. So long as the law gives the magistrate the power to remand, so be it, except the law is amended. But so long as the law is not amended, that law still gives the magistrate the power to remand. I think it will give the detaining authority the leeway, okay, not to keep somebody perpetually in detention without court order.
The essence of this is, usually, during the course of doing your investigation for the investigative bodies, they find out that they need to bring in this accused person. And the law is that you cannot detain anybody without a court order for more than 48 hours. So the challenge now is, this is a big man in court. We're bringing him for 48 hours. He knows we're onto him. We let him go. How do we prevent him from perhaps trying to muddle up the case or, destroying documents? We're still carrying out investigations. So in such instances, what I would prefer is for the Chief Judge to perhaps have directed that the investigative bodies, while they can come and ask for a remand order, it should be specific. They have to satisfy the magistrate on the reason why they want that order, what the summary of what their investigation is, and how long they need the person to be remanded for. I think within a week, 10 days, 2 days, after which, if the magistrate is satisfied that yes, there's a prima facie case, you are investigating, I'm satisfied, okay, I will remand him for 2 weeks, perhaps from the 1st of January to the 14th of January, and I expect you to charge him to court not later than 15th or 16th of January, failing which my order will lapse. You understand? So for you to say because somebody is a big shot, a former minister, a governor, or whatever, because if we say we are fighting corruption, you see, my own take on this whole issue has been, if you are fighting corruption, we have corruption cases that have spanned 10 years, 12 years, 15 years. It doesn't have to work like that. They realize that once you get bail, you appoint on brilliant lawyers and indefinitely it never gets ended. So my own personal opinion is, if you're on trial for corruption, after you've been granted bail, it's either you're put under house arrest or whatever, and then your trial is done speedily. There's no reason why a trial cannot be concluded in 2 or 3 weeks.
My own view about the CJ directives so far on the point is that where a court does not have jurisdiction over a matter, I strongly believe it's a wastage, judicial wastage of process to be given a remand order on such a case, because jurisdiction determines the power of the court. So in a situation where, for example, in Lagos State, the magistrate court, they can remand on issue of murder cases, issue of robbery matters, but fundamentally they don't have jurisdiction over this matter. So they will now say they are waiting for DPP advice. So why the prison continue to be congested day and day, and the innocent soul are even, suffering, because a suspect is strongly still believed to be innocent. On the contrary, it is proof. But where a court that does not have jurisdiction over a matter, remand is a kind of a waste of time. And to me, I support the view of the CG over this issue.
If the directive is to VIPs only, then that means that directive is a very, very negative directive, because you are now branding the legal system as some animals are equal, some are more equal than the others. Why all animals are equal, but some are more equal than the others? No, it should not look like that in the legal system. If the person that steals cow is being remanded, then the VIP that also steals cow or other valuables far more than cow should be remanded. So I don't see the reason why they should remind some and they should not remind some. We are all citizens of Nigeria. Once a crime is committed, it's crime is committed. So they should all face the music.